that there were legislative reforms. I had said that the story moved from the courtroom to the legislative forum. After that decision saying that it was discriminatory not to recognize same-sex people who live together, each legislature in the country made some reforms to its laws. All of them, in a sense, took the judgment as a signal that they could not continue to ignore same-sex couples. And the legislatures responded in various ways. Some of them included same-sex couples in existing definitions of spouses, and some did add some new definitions for a short time. What this means, though, is that effectively the sex of the partners by 1999 or 2000 had become largely irrelevant for a whole range of laws. And the reason is that I mentioned a little earlier that a lot of laws and social programs treated unmarried couples like married couples. And so once a distinction on the basis of sexual orientation has been excluded from the definition of unmarried couples, the expansion of laws to same-sex couples is largely achieved. Laws around income taxation, welfare, public pensions, who could be your next of kin, and so on. And I want to pause for a moment to note that in most of the cases I'm talking about where this legislative reform followed, what had been provided was not a voluntary way for same-sex couples to be recognized. It was the idea that social programs would treat people as spouses on the basis that they lived together. And so there were some concerns that people's freedom was reduced, that you lost the capacity to shape your relationship, and there was some sense as well that the economic implications of this unchosen recognition, if you like, may have been felt more severely by women, female couples, than by male couples. Some of the benefits provided by law are most relevant to people with children, female couples likelier to have children perhaps than male couples, and sometimes when recognizing a same-sex couple, household income was combined, and sometimes the government would withdraw the payments it provided. So the recognition cut both ways in some respects. At the moment, these legislative changes are being made, and same-sex couples are being recognized as equivalent to different-sex cohabiting couples. The Parliament of Canada, the Supreme Court, I'd said a moment ago, had insisted that nobody was talking about marriage. The Parliament of Canada, as the ambassador had noted, took the occasion. The very statute in which it recognized same-sex couples who lived together, this legislation, right at the top of it, had a provision saying that for greater certainty, the amendments in this law did not affect the meaning of the word marriage, the lawful union of one man and one woman to the exclusion of all others. So those are the sort of crucial contestations brought in court and the wave of legislative responses that followed them. And the next wave of things moves much closer. And now we come to the point where people are going to court and they are asking specifically for the right to marry. And it was mentioned that EGAL Canada, the NGO of which I'm president of the board, EGAL was involved in this litigation, but EGAL did not plan the timing of this, and people launched some of the litigation at a moment where some people associated with EGAL thought it might have been too soon perhaps after some of the judgments I had referred to. So the timing, no one was really controlling the timing. Some individual couples went to court and began proceedings, and things went from there. Cases seeking access to marriage, seeking the right for same-sex couples to get married were begun in several provinces. So it was moving across the country. And the question asked was essentially, did the traditional opposite-sex definition of marriage discriminate against same-sex couples? Did it violate their essential human dignity? Of course, the question is framed in ways using the language that the Supreme Court has set out in earlier equality cases. Does it demean them? Does it make same-sex couples feel less included and less valued and of lesser human worth? And so the litigation moved along. One province rejected the claim early on. Other courts in other provinces accepted the claim. The federal government was not on side and appealed these judgments. And there was a period where the state of the law was quite uncertain, and from province to province, the state of the law was different. In 2003, the highest court of Ontario, Canada's most populous province, released its judgment. And some of the other judgments up until that moment had accepted the claim that the definition of marriage was discriminatory, and they had accepted that gays and lesbians had the right to get married, but they had refused to order to make their order effective immediately. They had said, we need some time for Parliament to act. The highest court of Ontario in 2003 issued a judgment confirming its view that the Charter required the right to marry, but it also said these couples have waited long enough. If they have this right, they can exercise their right immediately. And so the same day, the first marriages for same-sex couples were performed in Ontario. We have a couple of very short excerpts from this decision. It's called Halpern, and it's been cited by courts in the United States and elsewhere. The court said in Halpern that denying same-sex couples the right to marry perpetuates the view that they are not capable of forming loving and lasting relationships, and that same-sex relationships are not worthy of the same respect and recognition of opposite-sex relationships. In Halpern, one of the arguments that the court rejected was that marriage was all about reproduction, and the court said that wasn't the case, that people who were not going to have children or who could not have children were able to get married, and they said that many same-sex couples, in any event, do raise children. The court also said that the societal significance of marriage and its benefits are significant, and excluding same-sex couples would perpetuate the view that their relationships are less worthy and would offend their dignity. And the last excerpt I have from the judgment, perhaps significant in your context, the court, and you'll remember from a few minutes ago, that the definition of marriage in Canada as it stood, I had said, came from an 1866 English judgment. So there wasn't a law that was being amended. There was this rule which came out of an English case. The court ordered that that rule be altered, that it be reformed. And in the court's view, the appropriate remedy was to change the definition of marriage from one man and one woman to the voluntary union for life of two persons. And so if you think through that approach, it doesn't matter what your sex is, what male, female, transgender, if the definition of marriage focuses on two persons, it's a single institution, open, in a sense, to everyone. That's the main end of the litigation route. And I'm going to turn now to what happened in the legislative forum when the Parliament of Canada responded. So the Parliament of Canada acted, and in 2005 it enacted the Civil Marriage Act. I believe it's distributed with some of the materials. But the core of that legislation is the statement that marriage for civil purposes is the lawful union of two persons to the exclusion of all others. And the reference to marriage for civil purposes is sending the message that religious institutions may continue to define marriage in a different way, and that the state is not purporting to overrule the way that religious associations might define marriage. The legislation also included this explicit statement that religious officers remained free to refuse to perform marriages that were not in accordance with their religious beliefs. So the intention was to make plain that there would be no direct impact on religious organizations. And to say the impact of this legislation, I had said a moment ago that there was uncertainty about the state of the law across the country. There was a moment as judgments kept coming in where it was almost hard to keep track of which of the 10 provinces and territories had recognized same-sex marriage, and the list honestly was changing pretty much from month to month. From 2005 and the adoption of this legislation, there was an equal position across the country with full and equal inclusion in marriage and its rights and obligations for those couples who took the steps to marry. So it's very significant. I do need to remind you, though, that much of the legal content of marriage had already been available to couples on the basis that they were living together. So it's both a significant step, but in a sense, if you think of the social and legal recognition as a big pie or a cake, much of the pie had already been available to couples living together. So it was significant, but it was politically perhaps less charged, politically less contentious than the marriage issue is in the United States, where so much remains tied to marriage. So the fact that the Canadian family and social policy had proceeded by recognizing unmarried couples first, I think smoothed considerably the path towards same-sex marriage. Okay, that's what I had thought to set out for the legal and social path, and I believe we now have some minutes for questions, right?
Hello. It's very interesting, a very fascinating lecture. We have known from the lecture that the Canadian experience, the legal system on the same-sex marriage undergo the judicialization, firstly judicialization of Canadian court, and then has been accepted as the Civil Marriage Act. Okay. From the lecture, do you have any questions? We have the microphone on the left and the right-hand side. Yes?
Hello, good morning. Hi, I am Inad of Asia Pacific Coalition of Male Sexual Health. I am from the Philippines and I am currently based in Bangkok. Congratulations to the very good professor. It's very impressive considering the amounts of efforts and energy directed towards the recognition of same-sex and their rights to have a marriage. My question is, did you, in any of your arguments, have the provisions of Universal Declaration of Human Rights being used as part of the defense that, or as a basis that same-sex couples have the right to marry, or did any of the court decisions refer to that provision in the Universal Declaration of Human Rights, stating that, particularly in the definition, because in the UDHR it says that both male and female, or both men and women, have the right to marry. It did not define marriage as a union between a man and a woman. It just stated that men and women has the right to marry. So did the court decisions refer to that provision, or did any of your arguments refer to that provision?
Thank you so much. I don't know with 100% certainty whether at some levels some of the international materials were cited. So I can't answer with perfect certainty. Given the recognition in the mid-90s of sexual orientation as sort of an unwritten basis for protection in the Canadian Constitution, I think that meant from that point forward that the conversation was focused in the Canadian context, was focused largely on the domestic development of the Canadian Charter of Rights, which was dating from 1982 a relatively new instrument, and so the lawyers were trying to persuade the court how to breathe life into this particularly Canadian instrument. So I think the international dimension would have done less work than it might well do in a different context.
Okay, may I add some comments to this question because regarding my specialization. So actually, there is the principle concerning the right to the family establishment in the UDHR, Universal Declarations on Human Rights, and as long as it would be crystallized as customary international law, it will, be sanctioning on the legal system of each state, and we have to apply that. And regarding the right to establishment of the family on the LGBT side, from my observation, it's still not yet crystallized as customary international law, but it's soft law. And we have the instruments as York Jakarta, which recognize the right of the LGBT, but we still need some stronger instrument in order to insist on the force, of this kind of principle. Okay.
I have a question concerning different. I understand that the development took place by coming in different angles and different levels, like national and provincial and litigation, as well as the parliamentarian aspects. But I want to understand if there are other actors in this process. For example, the cases that people brought against, like the last case you gave example of Harpen against Ontario, was that a work of an NGO, behind the person that was taking the case? Were there also involvement or support from independent organizations, such as what we have here in Thailand is National Human Rights Commission, National Law Reform Commission? So were there other organizations that participated in those different routes? And also in terms of the governmental bodies, we even have, for example, within the Ministry of Justice, we have a Right Protection Department, who also has been supporting this draft that has been drafted in Thailand. The last player I'd like to hear, if they are involved at all, is the international communities or mechanism or organization that have been behind different cases that were brought up. Thank you.
Thank you. So, Egal Canada, which I'm involved with, was a plaintiff in at least one of the cases. In others, individual people initiated action, and Egal came on to support or to intervene. There was the Metropolitan Community Church of Toronto, which is a very liberal and very gay-friendly religious association, was involved in the litigation as well. So there was a combination of civil society groups. I should indicate that there were religious organizations who got involved opposing some of the claims too, so that there was a range of participants in front of the courts. To my knowledge, there weren't international bodies involved in the litigation process in Canada. So that's an answer to that question.
Yes.
I'm coming from a German perspective on the issue, and I think we have to recognize that the Canadian way is actually the furthest going which can be achieved. And I was wondering whether there was ever in the movement and in the debates temptation or a discussion on whether to opt for just a separate civil union. You made the difference between complete integration into marriage or setting up a civil union mechanism. And was it just a lucky coincidence that the court in the Halpern case touched on the definition of marriage, or was there a positive choice to campaign for the maximum which can be reached? Because in Germany we now see we have a very far-reaching equality, but still detailed issues where there is a discrimination of gay couples against heterosexual married couples.
I think I said at the start of the talk that after several of the major rights decisions, so 1999 was the decision to recognize unmarried couples equally same-sex and different sex. And it was very soon after that that some couples began pushing for full marriage. And some of the activists felt that that was too soon, that that the effect of that might well be to have a court decision rejecting the claim, saying, you can't exclude same-sex couples entirely, but marriage is different. And so there was some sense, I think, on some people's part that we needed to wait for a while and maybe to work through the possibility as to whether a civil union might be acceptable or not. And there were some views differ on this. In part, the federal Canadian structure, which I mentioned at the beginning, comes into play a little bit, because the Parliament of Canada has power over marriage, and the provinces have power over other kinds of family law. And so when people in Ottawa were wondering whether, instead of amending marriage, they could create a civil union, there were some doubts over whether they would have constitutional power to do so, whether they could do anything, whether they had jurisdiction to do anything that wasn't actually marriage. And so that was one of the factors. People were also reading the judgments very closely to try to get a sense over where exactly the constitutional harm lay in excluding same-sex couples. The fact that unmarried couples were already recognized and that lower courts accepted the claim for marriage seemed to make it feel as if the symbolism associated with marriage itself was very significant. Because if at a moment in which you already have access to much of the legal rights and obligations, a further claim for marriage is accepted, it feels as if civil union itself is not going to be good enough. And so there was language in the Halpern judgment suggesting that really anything other than full inclusion in marriage would continue to exclude. Also, I mean, it's a kind of contingent element, but the reasoning process set out in the doctrine around Canadian equality claims calls for the government to justify why it limits someone's rights. And the governments really struggled actually explaining what the benefit to society was from excluding same-sex couples. So the government lawyers would say, but marriage is good for society, and the judges would say, well, what advantage is served by excluding other people who want to marry? Or and so I think the appetite for a separate but equal model, I think, was relatively small. The federal government asked our Supreme Court at some point several questions around its path forward, and the court actually refused to answer the key question on the basis that the government had stopped appealing the judgments, and the court wasn't going to lay out for it in detail quite what the options were. But I think the main actors in Canada took on the view that entry into marriage was what was necessary, and that having a separate model was not acceptable for the symbolic purposes. And what one can say today, I had thought I might mention this earlier, the idea of having a separate parallel institution, even if you say it's equal at home, even if you say, and I don't know what the experience in Germany has been on this, but the civil partnership in the United Kingdom was presented as being fully equal. Stop asking for marriage. We've created this civil partnership for you. It's as good as marriage. They don't travel very well. And the country that creates something that isn't marriage cannot guarantee how other countries that are used to recognizing marriages and nothing else, it's very hard to control how they will respond. And so Vigal at the moment is involved in litigation the question as to whether a UK civil partnership gives rise to the protections under marriage and divorce law in Canada, and it's not over yet. There's this whole issue of what to do. So there certainly are very practical advantages to something being called marriage rather than having this new sort of side avenue.
Yes.
Thank you very much, and I like others, I enjoyed the presentation. I want to take up on the question of marriage. It seems to me that maybe in societies which are increasingly secular, marriage, the distinction between marriage and civil partnerships may have less resonance, because the word marriage, I think, seems freighted with values which may be connected to religion or certain types of morality. I'm not sure, but so I want to sort of pursue that line of thought. But also, in your Canadian legislation, you also seem to have an opt-out clause for religious institutions to say, you know, in the context of freedom of expression and belief and so on, the religious institutions will not have to marry same-sex couples if it's against their religious beliefs. That seems to embed, to some extent, the possibility of discrimination. And I was wondering if that opt-out clause would apply to other bases of discrimination, for example, ethnicity or race. You know, what was the discussion around that, which seems to me like a compromise, but what were the discussions that allowed for that clause to be included in the legislation?
So that's a lot of questions, huh?
Yeah.
The ongoing value of marriage in an increasingly secular society, I mean, that will vary from context to context. The province of Quebec, where I live, has, I think, the lowest marriage rates of any jurisdiction in the sort of Western or global North. And so nobody gets married, whether gay, straight. 65% of children today are born to unmarried couples. So in a sense, the recognition of cohabitation on the basis of sexual orientation may matter much more in some context. The religious issue, again, some of these things are going to vary a lot from place to place. But in Canada, there are civil officials, state officials who perform legally binding marriages, and the state also will allow recognized religions to perform marriages to which it will ascribe, full legal status. And there are already differences between the religions who they will marry and the state rules. So that the Roman Catholic Church will not remarry divorced people, although they could get a civil marriage at City Hall or in front of a judge. And so the idea that the religious institutions would continue to be able to choose whom they would marry didn't feel radically different. I don't think it has much work to do in the text, and there are bases for saying that provision actually adds nothing to the law, but it's symbolically significant perhaps to some people. The Canadian Charter already guarantees freedom of religion, and so one could imagine that even without that clause, that no priest or rabbi would find him or herself compelled to marry a same-sex couple. The idea that this embeds discrimination, it actually strikes me as quite radical to suggest that the state would change the rules for civil marriage and impose them on all existing religious organizations. But we're kind of preempting the post-break conversation, but since you took me there, what has arisen in Canada as a question to be resolved is not whether you can compel a priest to marry a same-sex couple. What has arisen as a question in Canada is what to do with the clerk at the City Hall or the person who's known as a marriage commissioner who, for a little extra money or several times a year, will marry a couple in a civil ceremony. Some of these people who have been performing this function for years have said, I don't like gay couples, or my religion doesn't like gay couples, so I don't feel that I, even acting as a civil officer, should marry a same-sex couple. I would feel uncomfortable doing so. And there have been discussions around that, and that at first blush appears to set up